Record.
Well, good afternoon. I still see people are logging onto the system. We'll start here shortly. Welcome, everyone. Well, hello, everyone, and welcome. Thank you for joining our second event in a four-part enterprise webinar series focused on eviction prevention, intended to provide critical information, tools, and best practices to a wide range of partners, from property owners to tenant advocates to policymakers. I'm Jacqueline Wagner. I'm the president of the Solutions Division at Enterprise Community Partners, and I'm honored to lead a fantastic, dedicated team of mission-driven enterprises across the country who advocate for federal and local policy, create and deliver critical programs to communities, and provide capacity building and advisory services to thousands of partners. Enterprise is a national nonprofit housing organization that works coast to coast and is focused on three organizational-wide priorities: to increase housing supply, advance racial equity, and build resilience and upward mobility. We implement our work across three divisions: solutions, capital, and communities, that form the foundation of Enterprise's unique end-to-end approach. No other organization in the country addresses America's affordable housing crisis from every angle. We invest in creating and preserving affordable homes. We own and operate rental homes and provide resident services for more than 22,000 people in the Mid-Atlantic region. We advocate for policy and best practices that drive system change. And we operate on a national scale alongside thousands of local partners with an on-the-ground presence in urban and rural communities across the country. The combined impacts of an ongoing pandemic and a reckoning on race that have made systematic inequalities in our country even more profound have directly impacted America's renters. It has never been more important to focus on efforts of eviction, to prevent eviction, and ensure that every family has a stable, affordable home they can afford. This 4-part webinar series will run through October and is generously supported by JP Morgan Chase & Company. In this series, we look at the nexus between eviction prevention and housing preservation, preventing evictions through the legal system, landlords as stewards of affordable housing, and moving upstream to prevention. These topics could not have more urgency in this moment. As you know, last week, the Supreme Court struck down the CDC's eviction moratorium, leaving the 11 million renters who are currently behind on risk of eviction, and worse, putting them on the path to instability and even homelessness, all while the COVID pandemic rages on. And as with all crises, we know that people of color, and particularly Black women, will disproportionately bear the consequences of this decision. We all play a critical role in protecting vulnerable households. No one branch of government and no single private sector industry can do it alone. Today, we're focusing on the role of the judiciary because we know that the courts engage with tenants when they are their most vulnerable and at risk of losing the most basic of needs, shelter. Although state and local governments are working relentlessly to deliver emergency rental assistance, they have faced numerous obstacles and challenges due to the unprecedented amount of work required to set up such large-scale programs. Until this critical assistance reaches everyone in need, we must take action to bridge the gap. Officials from the U.S. Department of Justice have made a national call to judges, attorneys, and court administrators to institute protocols and practices that ensure household stability and help prevent the further spread of COVID. These efforts are vital to preserve housing stability for all struggling renters, and in particular, for renters in communities of color who have been disproportionately impacted by COVID health crisis and the resulting economic crisis and are disproportionately impacted by evictions. Today, I'm honored to be joined by an amazing set of speakers to discuss this important issue. We have roughly 730 registrants. I see roughly 330 present so far. And I want to introduce you to someone that we think is doing an amazing job. And before I move on to introduce him, I might open it up and turn it over to our esteemed partner leading the panel. And let me introduce you to Christine Stoneman of the Department of Justice, which is exhibiting incredible leadership under the Biden administration to minimize eviction. Christine will introduce and lead our distinguished panel. And when the opportunity arises, we will introduce you to Attorney General Ellison. Christine.
Well, thank you so much, Jacqueline, and all of you from Enterprise and everyone who has joined this call and joined this effort. I'm Christine Stoneman. I head one of the sections in the Civil Rights Division of the United States Department of Justice, and I have been on a team working in DOJ and across the federal agencies to engage with the Interagency Evictions Prevention Group and the White House to advance eviction diversion, legal representation, and access to justice actions related to the looming evictions crisis. I'm going to mention a few, and so will others, resources, some letters and other materials that have come from DOJ and our sister agencies and the White House. But please know that we will be circulating links and resources after the call. So don't think that you have to write it down or search or remember it. So I will start with I'm sorry, I just lost my page. I will start with the letter that was issued by the Associate Attorney General in June, on June 24th, when Associate Attorney General Vanita Gupta issued a letter to Chief Justices and state court administrators to encourage them to consider eviction diversion strategies that can help families and avoid the disruption and damage that evictions cause. She pointed to federal resources that can help courts navigate the crisis. And in her letter, like Jacqueline, she highlighted that studies show that women and people of color will be disproportionately affected. Women, particularly Black and Latina women, are evicted at higher rates than men. And this disparity has persisted through the pandemic as Black and Latinx and Asian families report that they are behind on rent at roughly double the rate of white families. Associate Attorney General Gupta went on to encourage state chief justices and court administrators to implement pre and post eviction diversion strategies to keep people housed and keep evictions off the docket, particularly as moratoria began to expire. These included requiring landlords to apply for rental assistance before filing, extending time in pending cases to allow for rental assistance applications to be resolved, modify summonses and other forms and filings, and partner with community-based organizations and legal services providers. Associate Attorney General Gupta and others from DOJ also participated in a White House summit that month in June, which feels so long ago. They focused on bringing together groups of judicial, state, and local leaders and CBOs from dozens of jurisdictions to identify options for ensuring that tenants and landlords knew about and had time to obtain rental assistance in lieu of evictions. They also highlighted that ERAP funds could be used by states and localities and courts to support eviction diversion programs. Chief justices from Texas and Michigan, and judges and leaders from Milwaukee and Tennessee and Philadelphia and so many others participated in these conversations in a continued effort to encourage courts and localities to institute pre and post eviction diversion strategies to keep people housed and keep evictions off that docket. Our work has been informed and enriched by the pre-existing and ongoing work of the National Center for State Courts and many of you and other panelists. You'll hear more from NCSC and other panelists in a bit. And at the invitation of NCSC, late in July, the Associate Attorney General spoke directly with the Conference of Chief Justices and State Court Administrators. And in fact, on August 11th, she and Attorney General Merrick Garland met with more than 35 state chief justices to discuss the housing and evictions crisis confronting our country. The Attorney General thanked the chief justices for their work on the issue and highlighted the associate's recent communications. I'm going to stop here and pick up a little bit more about what we've been doing more recently in August and turn it back to Jacqueline.
Well. Thank you so much, Christine. And by the way, folks that didn't grasp it, Christine Stolman is the chief of the Federal Coordination and Compliance Section of the U.S. Department of Justice, and she will be leading the panel discussion. We have our guest here. Hello, Attorney General Ellison. We're excited to have you here today.
Thank you.
Yeah, so let me just give you a little shout out and give you your due. Attorney General Ellis has been in public service for nearly 20 years. And in 2020, he took on a special prosecutor on the murder of George Floyd, and the entire country watched as he and his team worked to achieve justice. Thank you for that. And since the start of the pandemic, he has been an incredible ally to those of us working to prevent evictions. His office has leveraged the power of the legal system to protect Minnesota renters whose livelihoods, home, and safety have been put at risk. Attorney General, thank you so much for joining us today. And can you tell us about traditional consumer protections and to how you've changed from focusing on traditional consumer protections into one that works to prevent unnecessary evictions and work against housing stability. Welcome.
Well, thank you, Jacqueline. I'm so grateful to be here with y'all, and always a pleasure to talk with folks about housing, a topic I think we really do not spend nearly enough time talking about, given the fundamental nature of housing in the life of any family or any person. I mean, how are you supposed to raise a family if you don't have a decent, solid, safe place to live? I mean, it's kind of like trying to mix a cake without a bowl. All you got is a countertop, and the milk runs off the side, and the sugar runs off the side, and you can't keep anything together. That's what it's like trying to raise a family with no place to be. And so, and I'll also say this, Jacqueline, I mean, we can hardly ask people to shelter in place if they got no shelter, and so it was critical that the moratoriums on eviction jumped into place, critical moratoriums on foreclosure. As these things begin to unwind, we have our hands full, and we have to think about what it means. And so, to answer your question directly, I just read the statute. The statute says that we're supposed to stop unfair, discriminatory, and conduct in business, commerce, or trade. And that under Minnesota statute 8.31, and somebody can put it in the chat if they like, we're not, it did not say we can't. I mean, as far as I'm aware, a tenant is a consumer of housing services, right? So we just read the statute for what it allowed. Now, before we did, the AG didn't do any housing stuff. We just kind of let legal aid do it. And legal aid in Minnesota does a wonderful job, but there's not nearly enough of them. They're absolutely overwhelmed. And they do a great job at helping people one-on-one, but trying to bring systemic litigation to deal with a real recurring problem was tough for them. So what we decided to do was join forces and work together. And we just filed a lawsuit on Friday because there's a group called the owner of Broadmoor Valley, which is a manufactured housing facility, maintaining an abysmal, horrible way. You wouldn't tie a dog up in there, some of them places. And I mean that, but he lets people live there and charges them a lot of money to live there, has illegal lease provisions. So we sued him. And just like we sued this guy, Stephen Meldo, and nearly all of his clients were African-American women. And he had over 50 properties, and we're looking to do a lot of housing. So I don't want to talk too long because you probably got a lot of questions, or I want to hear your thoughts on these things, but we believe that any consumer statute can easily be read to protect tenants. It should be done. And we'd like to figure out how to deal with some of the housing, the ownership disparity. Because in Minnesota, 80% of the people who own their own home in general, but only about 24% of African Americans do. Which means that African Americans in Minnesota have a diminished opportunity to accumulate equity. And if you're going to go start a business or fund a college education or pay for your retirement, how do you do that? A lot of times it's your housing equity. So we're looking at this thing in a comprehensive way, and we want to solve some problems. So thank you to everyone.
Yeah, well, thank you so much for sharing that. And I think one of the powerful things that you said is that the partnerships that you established to pull this off, looking at leaders like you to look at the law and the judiciary practices to see what we can do to improve that. And I think what's unique in your situation is you've been able to establish strong agency partnerships, both within the executive branch, but also across other branches of governments. So to come up with this legislator into the eviction prevention. And I see that you're looking across that, looking at home ownership and looking at different housing types. So we really commend you for your leadership. We're excited that you were able to come here and join us. I'm sure you have so much more to share, but we're watching, we're learning, and the panel that we have coming behind you will also share more on that. So thank you so much for your time today, and keep up the good work. We're watching. Thank you.
Thank you. Let's get together and get some stuff done.
Yes, it sounds great. Thank you.
Bye now.
So I'm going to turn it back to Christine Stoneman so she can kick us off with our amazing panel, our expert panel. Christine.
Thank you so much. That was really terrific to hear. One of the things I noticed that the Attorney General was talking about was not just about eviction prevention, but also preventing unlawful eviction. So not just about eviction diversion, but also unlawful eviction. And so we can talk a little bit about that. I know in the Department of Justice, one way that we're cutting and looking at that is related to the Fair Housing Act and implementation of the Fair Housing Act to ensure that evictions and other housing actions are not conducted on prohibited bases. So, and as well, the Title VI of the Civil Rights Act of 1964, which prohibits race, color, and national origin, including language discrimination by recipients of federal funds, and protections for service members who are active duty as well. I did want to just highlight two more things from the Department of Justice that again tie into our next panelists. So on August 11th, the Attorney General met with 35 state court justices, thanks in large part to Zach and his colleagues over at the National Center of State Courts. And again, this is about the partnerships, right? Again, issued sort of a call to action around eviction diversion and applauded the work in state courts where some of these eviction diversion strategies that you'll hear about and that the Associate Attorney General had lifted up have been applied. They also have been listening, as has the White House, to judges and chief justices about what they need, and to state court administrators about the obstacles their courts are facing in combating the crisis. And as part of that, the Attorney General issued a call to action that Jacqueline discussed earlier. So he issued a call to action yesterday for the legal community to volunteer to prevent evictions. This was on top of a letter sent by the Secretary of the Treasury, the Secretary of Housing and Urban Development, and the Attorney General to governors, mayors, and state courts urging the use of emergency rental assistance to support legal aid and other and eviction diversion programs and representation. And yesterday, the deans of several 40, I think, law schools also sent a letter to committing to use their law students in clinical programs and other ways to support eviction diversion, applications for rental assistance, etc. Again, we'll be sending all of those pieces around. But I did wanted to share those things. And then I wanted to introduce you to the partners on this panel and get going with discussing some of their expertise. So Danielle Hirsch and Zach Sarno are principal court management consultants at the National Center for State Courts. And they have done just a remarkable job in pandemic-related support for the courts and also related to eviction diversion specifically. Eric Dunn is the Director of Litigation at the National Housing Law Project. And again, just heroic work. And the Honorable Annette Rizzo, who is with the Judicial Arbitration Mediation Services, is one of the leaders in trying to bring eviction diversion programs and her experience from the foreclosure crisis to address the current crisis. So I'm going to start with a question for Danielle and Zach from the National Center for State Courts. And thanks so much again for joining us and for all of our work, your work that you've done in partnership with the federal government. In this moment of crisis, what power do courts have to avoid or divert eviction, at least to make it fairer when eviction filings happen, now that at least the national moratorium has been lifted?
We have a few answers to that. And thank you to Enterprise and Christine, to you and for your work that you've done on this issue. I think I would start by saying, if you haven't already, if you're an advocate or if you're a court, please use our eviction diversion diagnostic tool, which is like a customized quiz. It gives you answers based on your choices that helps you develop a program for your jurisdiction with examples and with guidance and best practices that can really enable a court to establish an eviction diversion program. So as a first kind of principle, you can start doing that. That's something that there is funding available for, and that we are happy to help you develop. And I'll turn it to Danielle for a couple other options, and then we'll go back and forth and tell you some more things we had in our mind.
So for the past year or so, we've been providing technical assistance to a number of courts across the country in thinking about eviction diversion. And we'll give you some really concrete examples, but there are things that can be done. Full eviction diversion program, like you'll hear from Judge Rizzo in Philadelphia. There are court administrative orders and rules and processes that you can put in pen with a stroke of a pen that are also possible. But then there's like the information function that courts can do in sharing information about the availability of rental assistance, as well as just the convening power that courts have with different players within an ecosystem, including the rental assistance providers, to talk through issues. And so we've been working in a number of courts to try to work through all of those levers, and we've leveraged a lot of that learning into the tool that Zach mentioned. And we kind of think of eviction diversion in kind of three big buckets. There is full eviction diversion, which is eviction diversion where the court is taking a really active role in scheduling and communicating with the parties. There's medium eviction diversion where the court is still involved, but isn't the center of all of the scheduling. It kind of makes the space, encourages parties, and then they come back and report when it's over. And then there's light eviction diversion, which is really administrative orders, sharing information at the beginning, diverting the cases before they're filed. This would be pre-filing diversion. And none of those, all of those have merit, and it depends on your individual situation and the resources that you have as to what is appropriate. And we are here and would be eager to work with any court that wants to work with us to try to implement such things.
So the tool is at ncsc.org/eviction diversion. And if you're not quite ready to do a diversion program in your court system, judges still have the inherent power to control their case management. So if a case is ripe for rental assistance, or if there's an application pending, there's no reason a judicial officer cannot say, let's wait a minute and see if that rental assistance application gets accepted and if rental assistance money flows. So we encourage you to look into eviction diversion, but it's also worth noting that the court system right now, without any modifications at all, can still take a measure of time to allow for rental assistance to flow via the inherent power of the judicial system and the case management powers.
Two other things we wanted to quickly mention in the spirit of legal information and as well as case management. The first is courts convey a lot of information to both landlords and tenants through the court process. So courts can have good information on their websites. They can include information with the summons or a flyer with initial filings. They can also make announcements during court. They can co-locate housing rental assistance providers in courtrooms. One innovation that we recently learned about is through the Arizona court system in partnership with the Arizona Department of Emergency Services. And the court system oversees and manages probation services in Arizona. And mini grants went into 5 of the big metro probation departments across Arizona. And now all probationers are getting information about rental assistance. And it's not a traditional way we think about sharing information, but it's a really powerful one. And then similarly, another kind of spotlight on Arizona is they entered a really detailed court order at the Supreme Court level of the decentralized state, but they entered an order with specific guidance about the number of cases that were appropriate in an hour, and said that there should be no more than 25 cases because they're pushing for remote hearings and to ensure procedural fairness. And so there are models out there so that if you're interested, if you are not yourself a court personnel, but you're an advocate, there are ways to ground some of these asks in examples of jurisdictions who've done something similar.
Yeah, and the diagnostic tool, which we already mentioned, is a great foundation for that conversation. And it really creates like a document you can take to your court if you're not a court yourself to think through how you might approach that. And then the last thing I will say is that we feel strongly that courts should make sure that everyone knows rental assistance is available. And we are more than happy to help you with that. We have in fact created a public service announcement, which we will customize for your jurisdiction. Put your court logo on the front, with a rental assistance link on the back, and we'll do it for free. So if you want it, all this is going to come out, as Christine mentioned, the links will come following the webinar, but please do reach out because we would love to help you with that.
And
I'll turn to Danielle.
Yeah, the PSA is available both in English and with subtitles in Spanish, Russian, Vietnamese, Chinese, and there's one other language, but it escapes me at the moment. But so you should take us up on it. And the final point I think we'll make in this kind of opening part is another great example of a barrier that a jurisdiction identified and a way to overcome it. So the Tulsa, Oklahoma court system has a hub to provide, that's community driven, to provide eviction diversion assistance. And they discovered like a big barrier to getting people to court is public transportation and the available, like the way to get there. So they worked with the public transportation providers in Tulsa, and they now have a way to give you a free pass, which is with a QR code on your phone. You can ride public transportation to attend any eviction diversion related meeting for free using public transportation, so that you can't have the inability to afford to get to court be the reason you can't participate. So those are just some of the ways that courts and their partners are promoting diversion that we quite like.
Well, Danielle and Zach, I remember when I called you back in March, I think it was, saying, what are the good things that courts are already doing so that judges and you can talk to each other? And you were on it long ago. So grateful for everything that you have done and all of the ways that you have allowed judges to speak with other judges and community-based organizations and legal aid to access the same resources that chief justices are getting and that the governors and mayors are getting, so that and the local community, everybody's sort of speaking the same tools and the same resources and having access to you. So thank you so much for all you do. I did want to turn next to Eric Dunn from the National Housing Law Project. Eric, your national network includes legal services organizations grounded in the day-to-day experiences of people facing housing insecurity. What are you hearing from them about what's working and what could be done differently in the court system? I believe you're muted.
Whoops, I haven't done that in a long time. As I think just about everybody on today's call is probably well aware, last week the Supreme Court formally ended the CDC's eviction halt order. But advocates have been reporting for some time that effectively the CDC order really hadn't been stopping very many evictions, if any, in most of the country. Some judges were indulging in legal interpretations that effectively amounted to a workaround, finding that if you didn't move out at the end of your lease term, that was a lease violation, so you could be evicted for not moving out, which I think most people would find to be an absurd interpretation, or basically not looking at the landlord's motive for the eviction. So if the landlord used just a no-cause eviction notice rather than a formal non-payment of rent notice, the judge would say, well, this isn't based on non-payment of rent, this is just a no-cause notice. And even if the landlord admitted or the tenant could prove that it was based on the tenant being behind in rent, the court would just sort of throw its head in the sand and not stop the eviction. And I think what this is really indicative of, I've heard kind of this term of fatigue, judges being tired of eviction moratorium and restrictions, just feeling like it's just not fair to the landlord that a tenant should be able to stay in the property without paying rent. We actually heard of a case recently in Washington State where the judge had found that a landlord had not served a proper eviction notice, but it had been the second or third time the landlord had tried to do so. And the judge said, well, I'm still going to grant the eviction because this has just gone on too long. And this is very frustrating to advocates because, of course, it's judges' jobs to dismiss cases when they're not filed properly. The CDC order said, well, you can still file cases even when the order is in effect. You just can't physically put the tenant out. Housing advocates thought, well, that's not that big of a deal because under state law, you can't file the case until the tenant's occupying unlawfully. And if they're occupying under the CDC order, they're not there unlawfully. The case can't be filed. Judges just, in many places, just ignored that longstanding provision of state law. So I think, a lot of it just amounts to this idea, this fatigue or whatever it is, but it starts to look an awful lot like a lack of impartiality. So I think in a lot of jurisdictions, one thing I think courts need to do is make sure that they're not favoring a particular outcome, make sure they're not favoring, eviction proceedings just because they personally are tired of seeing tenants be able to keep their housing when they can't pay the rent. And even though the CDC order is not around anymore, we've seen the same types of rulings with other protections. The CARES Act, for instance, passed last summer. It's a federal statute still on the books, requires 30 days notice before a tenant in certain covered properties can be evicted. And yet we've seen judges say, well, that surely must not be in effect anymore. That was from last summer. That must have expired, right? No, it didn't. It did not sunset. It's still in the books. It's still federal law. And yet we see courts declining to figure out whether a property is covered or not, declining to apply that statute. So that's a big part of what I think courts need to be doing is remembering that they're supposed to be impartial arbiters, not putting their thumb on the scale. And it's not always intentional things. We saw last summer with a lot of courts reopening for remote hearings instead of having in-person hearings, adopting a lot of procedures in haste. And we're going to have our hearings on Zoom, and surely you can call in by Zoom and participate on your smartphone, right? Perhaps, but a lot of low-income tenants don't have, they have broken smartphones, the camera's not working right, they don't have a good internet connection. Maybe they can call in on the phone, but how are they going to show their evidence, their documents with a smartphone that they're on? They have a text message saved or something they want to show. Of course, not having procedures, not having any kind of technical assistance available to help people. We heard of courts just automatically defaulting tenants if they hadn't logged on to Zoom at the appointed time. Some of that's changed, but we still see shortcomings. There still aren't good procedures in a lot of places for tenants that need interpreters. In one particular court that I'm aware of, they have an 86-page guide of procedures for remote hearings. But to log on to a remote hearing, you've got to pay a fee. And in order to pay that fee, you've got to have a credit card. And a lot of lower income tenants are not going to be able to take advantage of that because they don't have those resources. So it's important that courts keep in mind the interests of low income tenants, of unrepresented tenants, and think through all these little procedures, when they have to change and adjust to circumstances, that there's not always people represented by counsel that can adjust to whatever the court comes up with. Also, eviction proceedings, it's a summary proceeding. Even in normal circumstances, when we don't have a public health crisis going on, we don't have, millions of people in an eviction queue that might, be evicted en masse. Summary proceedings are kind of just across the line for procedural due process. In 1972, in the Lindsay v. Norman case, the Supreme Court upheld them. It was a divided court, but upheld summary proceedings generally, even though, as Justice Douglas pointed out in his dissent, is that often it's just empty hearing. You have so little time to find an attorney, to appear in court, to prepare yourself, that chances are it's just going to be a pro forma superficial hearing a lot of times anyway. But nevertheless, the court upheld summary proceedings against official challenge in 1972 under normal circumstances. But we're in a pandemic, and the importance of the interest at stake, housing, is more important than ever, because not only do you lose your home if you're evicted, you lose your home during a public health crisis. It could put your own health of your family members at stake, as well as spread the disease throughout the community. So there's a higher interest at stake. the law is way more complicated in landlord tenant cases now than it ever has been in my career, probably ever has been before, because you've got all these state and local programs going on, different laws taking effect and expiring and being replaced. You've had different federal provisions in place. You've got the impact of rental assistance. You've got a lot of people that may have had some court proceedings go on a long time ago, and they've been waiting in their homes, and now they're facing eviction again. There may be new facts and new things that have occurred in the meantime, and how does this all play in? There's new procedures. Some courts are even holding hearings in different locations, or remote procedures that they adopted in haste. So the chances of somebody being wrongly evicted because they weren't able to identify an argument or defense they had, or because they weren't able to present the right kind of evidence they needed, is much higher than it would be even under normal circumstances. And of course, the government's interest in efficiency and speed in evictions is diminished compared with the public health crisis that we have. So all of the traditional public or procedural due process factors weigh in favor of the idea that tenants should have counsel when they're facing eviction during a pandemic. And this is something that judges need to be aware of and need to strongly consider appointing lawyers to represent pro se tenants, or refusing to proceed with eviction cases when there's not legal assistance available. Last, the eviction protections that have been in place have been by no means foolproof. As I mentioned, a lot of people were already being evicted despite the CDC order, from different legal interpretations, or judges just flat out ignoring it. Other state and local and federal protections have not been foolproof. And so there have been a lot of people evicted anyway. There have been a lot of people who moved out because they didn't know any better, or because they didn't want to acquire an eviction record. There's a lot of people that are living in housing that no longer works for them, that maybe they can't even really sustainably afford, because they have a landlord tenant debt, because they have an eviction record now. They were sued and the case got dismissed, but they're still there, but they don't want to be there, but they can't move somewhere because they have these records, they have these eviction records, they have landlord tenant debts, and they can't qualify for housing. And so people need to be able to get into new housing if they've been evicted before, if they've been displaced, if they're experiencing housing insecurity at the moment. And eviction records are an impediment to that. Courts need to have procedures to enable tenants to seal those eviction records so they can qualify for new housing. And I think it's important for courts to keep in mind that enabling tenants to seal eviction records is actually helpful to the fundamental dispute adjudication mission of a court to begin with. Because when you have housing providers that are just categorically refusing to rent to people just because they ever got sued for eviction, which is the most common policy, regardless of the outcome, even if you won your case, you still can't get housing because you got sued. That really eats away at the fundamental due process of court, because tenants know they can't even defend themselves, because once they set foot in the court, they've already got that record, they've already lost. So those are the main things I would say based on observations from our network, is remembering to be impartial, and that eviction is not the favored outcome by any stretch of the imagination. It's certainly not the role of the court to favor that outcome. That courts need to keep in mind the interests of low-income people, of unrepresented people, when they're developing new procedures, and that there need to be lawyers for unrepresented tenants that want representation, and there need to be procedures for sealing court records.
Incredibly helpful. Thank you, Eric. I know we are starting to get questions in the Q&A, and I just want to let folks know we will be following up with a question and answer period at the end here. But Eric, the legal aid community and legal services community, I was a baby lawyer in legal aid a long time ago, and I just have nothing but respect for the work that is being done, even absent the public health crisis, but during this crisis. And it's one of the reasons why the Attorney General and the Treasury Secretary and the HUD Secretary discussed this idea of using federal funds to support the right to counsel. So thank you so much. I do want to turn next to Judge Rizzo, because I think Judge Rizzo's experiences in program and leadership answers some of the hard questions that Eric just posed. So Judge Rizzo, the program you've set up in Philadelphia is a national model for eviction diversion. Can you describe the key features of that program and say, what do you think is most critical to its effectiveness?
Okay, right. Thank you, Christine, as well, for you and others, and for the Attorney General and what was shared. And I love the idea that I follow Eric and his comments, which really out of the box talk about a lot of fixes for some issues that are concerned from the bench. I really want to offer sort of another panacea with that. Not only my experience in doing diversion with the mortgage foreclosure issue, but also what we're seeing in Philadelphia now. Because it's I don't want to say it's a cafeteria plan, but it's a panacea of a lot of options. Because we do not have a chicken for every pot. I wish we did in terms of counsel for every tenant in need. So we have to look at some other tentacled court annex programs that can help in the moment. And so, we really are at that critical time. Thank you, DOJ, HUD, Treasury, for your call to arms for the whole legal community, courts, state and local officials, and our lawyers to come together to try to do something. So we appreciate all of that. I love the idea that we are here in this program to harness all of those resources to try to swim the same way in various queues to sustain housing for people in such vulnerable times. With the foreclosure, we learned a lot. We rolled it forward historically. So to know what we're doing with Philadelphia for eviction, we have to sort of look a little bit over our shoulders. And some things I even see in the Q&A I'd like to address of what was done in that forum that actually can help here. So, obviously, the thought is coming together of a lot of collaboration, all of what you've been talking about. That did not exist with foreclosure, okay? Ground up, we were trying to get our hands around it. And the biggest issue, frankly, was the fact that the courts were not fortified to have enough information about even what foreclosure was about and how everyone was on the cusp of it with now all of these loans going into default. That was a huge learning curve, which I am thrilled to know, even though we are in another crisis, that you have gotten it, and that all these resources have sent a call to arms to everyone to actually educate and actually offer things such as the National Center for State Courts toolkit, CFPB, seeing this as a consumer issue. All of that now tells us that we have learned from the past to understand that we have to triage this in many ways. So thank you for that. A lot of work, however, is ahead of us. So in terms of looking about the eviction program in Philadelphia, I want to start by saying in mortgage in 2008, major stakeholders came together and formed a program in Philadelphia in 7 weeks. This court annexed after filing. The focus here in Philadelphia now for eviction, particularly for diversion, is pre-suit. Pre-suit. So we do not have to chance worry front and center about the sealing of a record. The hope is we don't have a record, that we sustain the landlord-tenant relationship before it even gets to that point. That starts, of course, with City Council in last year coming together to pass what was the Philadelphia Emergency Housing Act. And part of it was to really task the city to set up a diversion program. Parallel with and in conjunction, like a ballet, the use of rental assistance programs. We've seen what has been done. There has been this national call to arms. We have these federal funds coming down. But woefully, when I read every stat, it makes my heart sink that so much money is being left on the table. Unacceptable. Unacceptable. So what we have to do is ground up, start to tee up an infrastructure that brings together all of these stakeholders, state and local, the court system, the local attorneys that handle public interest attorneys, Bar Association, Office of Housing and Community Development. Everyone has to come together to make this work. We know there's glitches, of course, in these systems that actually access rental assistance, but parallel with a lot of collaboration and word to get out, I think that we can really come together on that. So what does that look like? Now that the program was set up, it actually was endorsed then by our local court, the municipal court, through our president judge of that division, as well as the judge involved with it, to actually say that as of April, continuing through October 31, you have to file for rental assistance as well be automatically enrolled in the diversion program and wait 45 days before there can be a filing of a lawsuit to start the eviction process. That's a window of time. May adjust, it may not work well. You can file 45 days past without your rental assistance coming forward, but at least it gives that needed pause so that tenants can stabilize themselves. And it works. We have had the opportunity with the money that has been put through ERAP down, state, some local funds with federal. I am happy to report, and as part of the dashboard I did provide to the organizers here of this website, $158 million has been distributed for rental and utility assistance to some 28,380 households to date. We've almost spent through phase 4 of our funding. The hope is that we have supplemental funding to actually sustain ourselves with the need and want. So I know there's a lot to deal with in terms of setting up an infrastructure. This is a call to arms. So there are resources, hopefully local, that can come together to actually start that platform. When it is time to reach out to the courts, local agencies must modify court procedures. You must make the ask. This is what has been discussed of the local courts to give that pause so that this rental assistance can trickle through. That's just part of it. But what is the beauty of it is to have a diversion system, which actually puts us into a setting with a trained mediator. And I have to say today, this program is run by Cora, Good Shepherd Mediation Program. We have a cohort of approximately 75 mediators trained for this program. I'm proud to say 20 of my JAMS colleagues have trained across the country to serve Philadelphia in that role. And actually telephonically, I thought it wasn't going to work, but it does, to bring people together, the tenant with the landlord attorney, with the landlord called in, as well as the mediator and a housing counselor to start the conversation. And this is the critical part. This was borrowed from mortgage. It helps, it makes a difference in so many ways to have our housing counselors part of the discussion. They are there to support in so many ways what conversation has to be done, to give the tenants support, to triage what their financial needs are, to not only help them in the moment to negotiate a proper sustainable agreement where they can take care of rent forward with rental assistance as well as arrearage, but also to stabilize them with needed financial literacy training or actually connecting them to other needed services throughout the city. It's a hub. And so I am a big believer and a zealot to have housing counseling as part of any mediation program to stabilize these tenants. We've seen the success of it. We have 30 agencies. We're very blessed in Philadelphia already established, who actually pivoted from doing mortgage foreclosure counseling to now what is now for landlord tenant. And obviously these resources will be tapped once the moratorium lift to go into full force with mortgage. But here's the big thing about it, and I think we talked about it. Your next session on this 4-part series will deal with the involvement of landlords. They are stakeholders to this. You cannot ignore their needs in the sense of having the discussion to work out a sustainable relationship and agreement. In addition, you are connecting landlords to perchance needed services, to upgrade, to make sure their property is habitable. That conversation will also take place in this setting. So it's a holistic approach to sustain what is good housing, stable housing for our tenants, as well as making the landlords able to provide that service under proper licensing and proper habitability requirements. In addition, we don't want them to fall into foreclosure. We don't want that. So therefore, a connection early on will get the landlords connected to services that will help advise them to sustain their properties and not become of the mortgage foreclosure diversion program. This is the hub that really means that we can collaborate. So with buy-in from the court system to give us the platform to have these systems work through in terms of having important conversations and accessing, thankfully, rental assistance that is available. No dollar should be left on the table throughout this country to make sure that we have sustained housing. That is the bottom line. The need is there. We know that. Now we just have to work out the systems. And as much as I'm distressed when I hear Art mention on individual cases, what could be disappointment of judicial approach, either on a case-by-case basis or systemically, pitch is the following. Courts, you have an burgeoning caseload docket system, particularly with COVID, in not just landlord tenant, but also other types of cases. So case management is the pinnacle from their side of the equation is vital. Collaboration with these services and these other partners to really make the system work pre-suit, that really helps them in the long run in so many ways. Advertisement of it. I heard about court proceedings having actually written documents or notices. We did that in foreclosure. We sent it out in a variety of languages. We also used, and I just throw this out, notices in utility bills. We had neighborhood community groups used to do door knock. Pandemic has really limited that, but nonetheless, hopefully, as we punch out as a resource. We had advertisements on buses. We had PSAs by the mayor. Whatever it took to get the message out to make people come into the program. And what were they told to do? One piece of information: to call the hotline. Have a tenant action hotline that immediately triages our cases, and not just in a minute, but actually to find out what the issue is and connect them with a housing counselor who will shepherd them through these like stormy times and to actually again connect them to services. It's all about the word mentioned, and I live by ecosystem, where people with specialties can come together and coordinate resources to sustain all of this. You sustain a home, sustain a block, a neighborhood, a community, a city, a region. It's just ground up. Necessity commands it, and I think we really know what we have learned, that we can do this, particularly in this instance with eviction. There's just so much more guidance and coordination from DOJ and CFPB, Treasury and HUD, and that was not existing before. So I love the idea. I heard about Indiana, where court systems are coming to the table to learn, and court administrators want to learn. That's where our message should get the word out of options and opportunities as part of a cafeteria plan that really in your jurisdiction can provide data that is vital. And I refer back to that Philly dashboard. I'm proud to know that we're spending down all our money, every last penny, and we're asking for more. Every jurisdiction should have that mantra. And in that instance, to also have a breakdown of demographics, which unfortunately underscores what has been mentioned before, that women of color, they're, as heads of households, are most affected. Unacceptable. We got to use the data and see where the needs are, and then pivot that to make sure that we have a leverage of resources to those most vulnerable communities. We can do this. We can do this, and necessity claims it. So I guess my bottom line is I just have a few points to raise that I would first of all invite talking to anyone. I had an opportunity to do that, and I am a zealot on all of this. But listen, your own jurisdiction, have a champion that really leads the charge to really want this to happen and coordinate team. Tend to your own garden. Appreciate that local jurisdiction with local rules may be different to the township or community or county next to you. That the state system, with wonderful buy-in by the Chief Justice and the Supreme Court of that particular state or Commonwealth, is great. Round up, you got to get buy-in from your local court system. Let that marriage happen. Foster that conversation to make them be as well enthusiastic and a champion as well to get this for their own court management tools. But understanding that there can be, even in local elements, passage of laws that can really help with respect to the sealing of records, just say if eviction cases are filed, or having certain ways. We have restriction in Philadelphia with a recent law passed about how data on prior eviction history of a tenant can be used as you go forward in the next tenancy. Look at your stakeholders, continue to grow, and your ecosystem leaders, and making sure that landlords as well are part of that conversation, a must. Data, look at your data, continue to evaluate, and most of all, continue to listen and observe and learn from those who are in the moment, those who are providing the services. The housing counselors are wonderful to give eyes and ears of what was working and not, as they really held the hand and hip to hip, traveled with tenants as they worked through the system. There's so much to do, but I just think there's such a different platform now than existed before to really have things happen in the moment. So I salute the leaders and those who are thought leaders and actual leaders on the ground up, locally and nationally, starting, Christine, with your team there, of course, at DOJ and all the other state and federal agencies. Amazing. AG's amazing. Let's not keep it up. Let's keep our how can I say it? The gravitas of the moment is behind us. Let's match it with our own enthusiasm and not giving it up.
Yes.
This is a moment. It's a call to arms for everyone.
Yeah, Judge Rizzo, I mean, you are amazing, and we have all learned from you and are trying to catch up, to be quite honest. Thank you so much for those words. I just want to sort of reiterate that that with the moratorium having expired, the Attorney General has really issued a call to action. And that includes everyone, as Judge Rizzo just said. And I just want to point out that he reflected on a different call to action that Attorney General Robert Kennedy issued back in the height of the civil rights movement. And he said, as part of their obligation to support equal justice under law, it is the members of the legal profession, it is on us to use our legal knowledge and skills to advance the rights of those who were most vulnerable. And once again, the legal community has this obligation to help those who are most vulnerable. And to do that, we can really work together to ensure that people have a meaningful opportunity to stay in their homes and that eviction procedures are carried out in a fair and just manner. And that's the message from the Attorney General to the legal community, but really to everyone involved here. So I just want to pivot now to the entire panel, because we've had some questions that I think are really foundational and really necessary for us to get at. Many questions. One of them is, if I am a renter or representing a renter in the process of eviction, what do I do? Where do I go? Who are the agents? What are the agencies that can help me? Eric, do you want to start with that?
Yeah, so there are federally funded legal aid programs in every state. Often you can access those either by calling a single number or by doing a web search for legal aid in your area. If you don't qualify for the federally funded programs, there are often non-federally funded programs that have broader or different eligibility criteria, so you may be able to get help from one of those programs. In many communities, there are pro bono programs that provide volunteer lawyers in housing cases. So certainly try to get help. Make sure you apply for rental assistance, or make sure that your landlord applies for it on your behalf. And don't skip your court date. Don't put your summons at the bottom of a pile of papers and forget about it, because it's not going to go away. Go to court, ask, there may be resources there, people that can help you. From that point, it's going to differ in every community. But if you're representing a tenant, somebody wrote an law review article. The title is, you didn't pay the rent, so what? I mean, it's not over. There are defenses. There may be some kind of eviction protection in your local jurisdiction or in your state. If your client has applied for rental assistance, the court may be willing to hold off on that case to see if the client's approved, and if the money comes through, pay off the debt. Even if state law doesn't necessarily require the case to be dismissed, the matter's been resolved. Make sure that the proper procedure was followed. Did your client get the right eviction notice? Was it served in the proper way? Get all the facts behind the eviction. Are there habitability issues that could be raised as set-off claims? If you're not a housing lawyer and you don't know these things already, go get training. Go at least talk to the legal aid program and get some advice. And we have a lot of resources on our website, nhlp.org, both specific to the COVID, housing issues during COVID, as well as general. So I guess I'll stop there, but there's lots that both lawyers and tenants themselves can do.
Christine, if I could just offer, I think everything Eric said is absolutely correct, obviously, but you can also go to ncsc.org/eviction. And we have listed there a map of resources for lawyers to volunteer and for people looking for help, with every housing legal aid agency that we can find at the moment listed on a map. So I do encourage you to look there, and we want to help. So please do.
I think also the CFPB has a good breakdown state by state. I mean, it's amazing that these resources and they intersect. The but there's much more available online. And just call the local jurisdiction, come over come and talk to me, come and talk to all these wonderful people. Reach out, it's too vital.
Oh, that's terrific. Thank you. And I did notice that one of the questions was whether or not panelists would be interested in participating in additional panels that might be hosted by the audience. I think I would venture to guess that the answer to that is yes. Feel free to reach out.
Absolutely not. Do not contact us. No. We're very happy to help.
Yeah.
We'd be pleased to. Yeah.
And we can talk specifically with particular jurisdictions about how to approach your court system. We have some slides that already exist that we'd be happy to do that are kind of like everything you needed to learn, you learned from kindergarten, but our version is everything you need to learn to engage with your local court. And we'd be happy to do that if it would be useful.
So another question sort of related, but from a slightly different frame. We've been talking about courts in the legal community. One of the questions was, what about the local county legislators? I mean, what can a county board do to pass a local moratorium or buy more time or do whatever it is? And is that something folks that NCSC might be able to talk to folks about? What can be done from the legislative perspective?
Sure. I mean, I have two initial thoughts and then Zach can clean up for whatever I don't remember. The first is a lot of the time sealing of court records has to be set at a legislative level. Courts have public transparency requirements. And so barring some kind of authority, it is often difficult to get records sealed. And so engaging at your state or local level about that could be very useful. DC has a really incredible sealing provision that the DC City Council passed is one example of what can be done. The second thing is courts are funded in a dizzying patchwork of ways, but a lot of courts are funded at the local level. And so programs like the one in Philadelphia, they take resources. And the court in Philadelphia isn't playing the key role. It is an ecosystem around the court, although the court is playing an important role, but it's not the key role. But regardless of which version you have, it takes funding. And so I would argue that communicating with your local legislature, who's often really responsive to the communities that they serve, may be an excellent way to help figure out how to find funding to support eviction diversion or sealing or any number of outreach efforts, or to kind of connect people if you haven't done so already. And then the same thing with your emergency rental assistance providers in your jurisdiction. We're in an unprecedented amount of time with $46 billion at the state and local level, which the Treasury guidance makes very clear can be used for all of these purposes: eviction diversion, mediation, legal services. So let's make asks to try to get some of that funding to set up these programs. Both Christine and Zach have heard me say this before, but I really feel like this is a moment where we can improve eviction courts for the long term. And part of that is setting up these programs and showing why they work. And there are the potential resources out there to do some of that. So
I'd like to weigh in on one aspect of it. Just currently, I think within the last week, the Philadelphia Bar Association, go to your bar associations to put through what was a bar association edict or order to call upon the courts actually to pass legislation regarding the sealing of records. Now that more so in the Commonwealth and more so in Philadelphia is to have it as a court ruling as opposed to one legislative. But the city council in Philadelphia is not shy. In fact, they actually started the conversation to try to do something aggressively with eviction when COVID came into play. So they have issued a host of laws that actually set the table for the court then to step in and control its own docket. Okay, so courts will always be controlling their own dockets in the court system. That's why in partnership, that's really, really, really critical. And I agree with you in funding to go to various sources. And then those sources can be in advertising of the program, in training sessions with local community groups. City council has constituent services. You can go out. We did this in mortgage. We went to local communities, just get the word out. But things like utility bills, however, can be a way. Call this hotline. Just make it a simple message. get everyone into the chute, and then take it from there to help them.
Thank you so much. Eric, I'd love to get your take on this question too, but I also just wanted to add another question that I think is best directed to you. So it'll be like a 1-2 question here. So this first question is about the legislative approach, but also there's a lot of conversation in the Q&A about other housing, other practices by landlords that are extremely concerning. And how can folks get housing courts to be more of a place to hold landlords accountable for codes and providing clean, quality living space so that you're not basically constructively evicted? So I'm going to pitch it to you, Eric.
Well, in terms of local legislative action, the state of New Jersey just recently passed something that we've been urging throughout the pandemic. Our term for it is non-evictable debt. But it's basically this idea that, look, if somebody fell behind on their rent before and they accumulated a rent arrearage, but they're back to work and they're able to pay their current rent, going forward, they can stay current. So we're just talking about what they owe from before. Let them stay. Prohibit evictions of those people. They can apply for rental assistance to pay that debt off. If they can't get rental assistance, they can do a payment plan. Whatever, but it doesn't do anybody any good to evict those tenants just over an arrearage. Because if the landlord brings in a new tenant to replace them, the new tenant's not paying the arrearage either. So all you're doing is destabilizing communities, destabilizing households, really just to enable landlords to have this tool of making people homeless to pressure them into paying a debt. And that's not what we need to be doing. So that's my number one recommendations to local government is non-evictable debt. Let the people that are paying their current rent from here forward stay, and we'll worry about the arrearage later. Secondly, and Judge Rizzo talked about a lot of this, because Philadelphia just recently passed a great version of this, is tenant screening protections basically for people that need to get into new housing. The Philadelphia model basically says you can't just automatically deny anybody a new apartment because they have an eviction record. You have to give them a chance for a human being to look at the circumstances and decide, is this really a good reason to turn somebody down? Instead of having, what we normally see is a computer machine reads somebody's background and spots an unlawful detainer filing and sends an electronic message to the leasing agent that causes a red flag to appear on the screen. And the leasing agent says, well, you're denied. I can't even tell you what. In order for this to work, landlords need to be able to tell people why they were denied and give them a chance to explain, basically have an appeal type procedure. And that's what the Philadelphia ordinance does. There are other versions of this that we could get into, but the gist of it is make it possible for people to get back into housing, even if they've been through an eviction, even if they have a landlord tenant debt. And that's a very important thing for local legislatures to do. And I think will become increasingly important as we see even more evictions filed coming up. In terms of making housing court a place where tenants can challenge some of the habitability issues and discrimination problems and other things, where the landlord is really, doing something wrong, or at least not abiding by the tenant's rights. In a lot of jurisdictions, the whole point of an eviction case, it's a summary proceeding. The question is who's entitled to possession of this property at this particular point in time, and we don't care about anything else. And so a lot of these issues get pushed off to the side. Well, if you've got a habitability complaint, you can raise that some other time. Or if you've got a discrimination complaint, that's not what this hearing is about. Well, you don't have to do it that way. And a lot of times habitability issues do pertain to the right to possession, because if you're being sued for non-payment of rent and the place that you're living in isn't in good condition, well, you shouldn't have to pay full rent for it. So maybe we should add up how much of a rent discount you're entitled to and see whether you actually failed to pay rent after all. Or maybe if the landlord hadn't denied the reasonable accommodation you asked for, then you wouldn't have violated the lease. Getting rid of some of these archaic doctrines around excluding certain types of issues and arguments from landlord and tenant court, is one step. A lot of times, even if you're allowed to raise these things, there's procedures you have to jump through beforehand. So habitability, a lot of states say, well, you had to have made a complaint to the landlord in writing at least 30 days ahead of time, and you didn't do that, so we can't hear your. But Your Honor, I have a picture of water streaming in through the roof. Well, it doesn't matter statute, right? So we need to get rid of those types of procedural barriers. But even then, without counsel, without legal representation, it's awfully difficult for tenants to bring sort of affirmative claims against landlords and get meaningful relief on those sorts of things.
But I gotta say, I have to say, he's right and right to counsel, but if we get, I guess I'm again harping on the mediation pre-suit, I've actually had it in my own sessions where I have brought up habitability. I've served as a mediator. But that conversation has taken place in that moment because I'm asking those questions as our other trained mediators. That's the moment. You have to get the landlord online. What are you going to do for this? Or I'm going to follow up. It's one case at a time. And that is at least not going to change total culture, but start to have a conversation where it's not now in the COVID moment talking about the arrears of rent because there's no employment or things such as that or hardship. It's about a culture shift long term. That conversations such as this will be dealing with holistically the living situation of the tenant, holding a landlord responsible for what is our habitability and licensing and everything that's proper. That gives the pause for that conversation in a formalized setting. So we have addressed some of that and not hopefully go through the pitfalls of what Eric, you have mentioned in this patchwork of court systems where it's, it's just an inconsistent outcome, right? That tenant is being heard on those issues. And all that is seen is that you are behind in rent and therefore there's, where's possession of the property. These landlords out of possession may not even know, or they're big, they're small, whatever it is. That pause, that conversation can bring that to bear.
That's a great point. I think too, if you do have pre-filing diversion programs, if you do have a lot of cases going through that, then you have a lot fewer cases for the court to deal with. And it's more practical to have lawyers for people. It's more practical to have longer hearings and actually find facts. If all you've got every day is an eviction docket with 150 cases to hear in 2 hours, there's not time. And judges, they don't want to get backed up. They got to get through their docket. And they can't afford to spend 25 minutes hearing a case.
No, this is such a good point that the combination of averting the filing in the first place and diverting it once it's filed, and then if it isn't averted or diverted, the right to counsel that's the package, it seems. We did have a question about whether or not we could provide examples, and maybe we can do this in the resources that we send out later of all of the right to counsel, all of the places where there is right to counsel in housing and how that was set up. So I don't know if Zach and Danielle, if you want to just highlight a couple, or if we should just send those out in the resources, you let me know.
Yeah, we can certainly circulate that with the resources. The National Right to Counsel movement has a website that we can share.
Great, thank you. That's terrific. So I want to flip back to something in our final minutes that Danielle said, which is how can we take this moment, which is a really difficult and challenging moment, but also a moment where everyone where lots of the key players, whether they be legislators or attorneys or the federal government or the state government or the chief justices or the local court chiefs or the state court chiefs in different counties, whoever it may be, the legal services program, pro bono attorneys, et cetera. How can we take this moment and turn it into something that isn't just a Band-Aid for an evictions crisis on account of COVID, but rather is a way to move forward in dealing with evictions differently? Danielle?
Well, maybe I'll start by saying I think part of it is finding these good examples and hoping to have the data and to be able to tell the stories of why these work and get more courts to do it, so that when you have all these players in place and you have court facilitators and navigators and pre-filing programs, that they prove their benefit, and that courts continue, and that maybe if we were to have a conversation like this in 10 years, like our theory of the change would be that a lot of courts already have these positions in place because it just is a much more humane, thoughtful, procedurally fair way to hear these cases. We probably won't have the level of rental assistance at the federal level like we have right now, but perhaps other community sources will realize the benefit of going upstream, and we can, I guess, and to solve it, I think Zach and I spend a lot of our time, we think about the court part. And I think from Philly and many other places, Chicago and other jurisdictions, we have all across Michigan, we have a sense of the mechanics of what's necessary. And now it's just getting the political will. And I think this is an opportunity with all of those different players that you mentioned, Christine, to make some of these asks. Let's put these programs in place all over the country while we have the money to do it. And then we can figure out how to maintain it when it's done. But, I think we have seen in these jurisdictions that eviction diversion helps, and it helps landlords, and it helps tenants, and it helps the courts. And we just need more and more examples of it. And I guess, Zach and I are here to help with your court. So if you need help trying to figure out what that should look like, or to have conversations with your court, please feel free to reach out to us. This is, we are an association for courts, and we would be happy to help.
Yeah, and I just have to say, just by culture, it gets baked in. I thought the mortgage foreclosure diversion program in Philadelphia at best will be out of business 5 years. That was from 2008. It's now part of the system. The fact that there is actually civil conversation going on with lender servicers, and public interest lawyers, that there's ways that are developed for what we call graceful exit. If, say, a family has to leave a property, so to in tenancy, having conversation does make a difference. This just isn't willy-nilly. It is purposeful. It's postponement with purpose. Really work out a system, and you will find there will be a culture shift. It will happen in the courts and also all the other attendant service providers that work in concert. It will be a want, not just need, but a want for everyone as you go forward out of this, as we kick out of this. I've seen it happen in other jurisdictions, and this is right for it. So.
Thanks. Eric, do you have thoughts on this question and any of the data we might want to be trying to collect to prove the points?
Well, I certainly agree that, most eviction cases are for non-payment of rent, and it's not really, that the tenant committed a crime of moral turpitude that needs to be adjudicated by a tribunal of justice. It's a social problem that needs to be dealt with, more of a social work type setting. So I certainly agree that having that type of cultural shift, is what we need to see. And some of the data that I've seen already, the Eviction Lab issued a report, I think late last year, earlier this year, where they looked at several different cities, like how much money is actually causing people to be evicted. In Cincinnati, for instance, half the evictions were for less than $1,200. In Phoenix, it was half for less than $1,700. So pretty modest amounts of money, really, when you think about it, that, somebody's entire life gets turned upside down because they're $1,200 short with their landlord. So, certainly with the pandemic, and you've had people that have been out of work for months that have racked up, 5 figures in some cases. It's a bit of a different deal, but I think, in the future, things can get, back to sort of normal, quote unquote, times. It wouldn't take $46 billion to keep something like this happening. And then I think there definitely needs to be more data collected on the demographics of who's in eviction court. We've seen what's happened with criminal history screening, where just 5 or 6 years ago, it was widespread that housing providers would often have just absolute blanket bans. They just wouldn't rent to anybody with any kind of criminal history. They would advertise, don't even bother applying unless you have a clean criminal history. You can't have, not even like a dismissed arrest, they would turn you down. And now, landlords have by and large moved toward trying to have nuanced policies, trying to have procedures for individualized reviews. And that's because data has shown that African-American and Latino people tend to have criminal records at grossly disproportionate rates, even though they don't commit crimes at disproportionate rates. And if you have these kind of over-exclusive policies, it's discriminatory and they can't be justified. And the same thing is undoubtedly true of eviction records. Whenever it's been studied, it's been shown that Black women, especially mothers, have disproportionately higher rates of eviction everywhere. I was involved in a case in Seattle where it was more than 7 times when our expert did his first review, and then he came back a while later, told me actually it was 13 times the rate of whites for Black women to be sued for eviction. And that's been true everywhere that it's been studied. But the data on evictions nationally, it's hard to come by, it's incomplete. A lot of times demographic information is not included. So, making more of that information available so we can study the problem better will lead to better solutions, and it will, give advocates tools they can use to, try to make change with the things we already have to work with.
Thank you so much. Well, I just want to thank everyone on the panel. I want to thank all of the participants. There were questions that we would love to be able to get to, and maybe we can continue as we share resources to try to identify some answers to some of those questions. And I'm again so grateful to Enterprise for bringing all of these folks together, and for bringing all of the participants together, and for your time on this incredibly important issue at this incredibly challenging time. So I'm going to turn it back over to Jenny with great thanks to all of the panel.
Thank you, Christine.
Thank you all again. That was an amazing discussion, and we are so honored to have you, our esteemed speakers, here today. And thanks to all of you who have joined us. Thanks for listening and advocating in your own communities. I also want to thank the Enterprise team who's back behind the curtain, who have been putting this webinar and other sessions together. We're going to be sending out follow-up information. We can see in the chat that many of you would really like some of these links, resources that have been mentioned. As Christine said, we'll try to answer some of the questions that we didn't get to. We're so glad that you asked them. And so look for a recording and links to additional materials. Our next webinar is going to be September 28th on the role of landlords as stewards of affordable housing and housing stability. And to Danielle's point, our last webinar in October is going to dive into upstream strategies to increase housing stability. I also want to mention that we have a webinar on October 6th. This session is going to feature a slate of rural housing advocates and experts as they explore why preservation is an important issue for rural communities and what work is being done to ensure that subsidized housing stock is rehabilitated and stays affordable in rural communities, because we know that one of the keys to preventing evictions and housing stability is to make sure that we have a safe and affordable place for people to live. So please sign up on our website to receive information on future webinars, and also look for a forthcoming paper that we will be publishing most likely alongside that October eviction prevention webinar focused on upstream eviction prevention strategies and best practices from around the country. Thank you all so much for joining us today. Thanks again to our panelists, and we'll see you next time.
Okay.